Buckfire Law.
Hi, I'm Bob Lantzy, an attorney with the Buckfire Law firm. If you suffered carbon monoxide poisoning while staying in an Airbnb or Vrbo rental in Michigan, you may have the right to file a civil lawsuit. But identifying the legally responsible party is critical. Short-term rental properties are typically owned and maintained by an individual property owner, not by Airbnb or Vrbo directly. Under Michigan premises liability law, the party who owns, manages, or controls the property has a legal duty to maintain reasonably safe conditions for guests. Carbon monoxide is a colorless, odorless gas that can cause serious brain injury or death. Michigan law requires functioning carbon monoxide detectors in certain residential properties. If a rental property lacked working detectors, had defective appliances, improper ventilation, or poorly maintained heating systems, the owner may be liable for resulting injuries. In some cases, property management companies or maintenance contractors may also share responsibility if they failed to inspect or repair hazardous conditions. A civil claim must establish that a dangerous condition existed, the property owner knew or should have known about it, reasonable safety measures were not taken, and that the failure caused your injury. Carbon monoxide poisoning cases often involve medical records, inspection reports, appliance maintenance documentation, and expert analysis. While Airbnb and Vrbo are booking platforms, liability may depend on their level of control or involvement in safety practices, which requires careful legal evaluation. At the Buckfire Law Firm, we investigate short-term rental carbon monoxide cases thoroughly. We identify responsible parties, analyze building safety compliance, and pursue compensation for medical expenses, long-term health effects, pain and suffering, and other damages. If you were injured by carbon monoxide at a rental property, contact us for a free consultation to evaluate your legal options under Michigan law.